Great, we'll get started. So welcome to, good afternoon and welcome to this webinar. Before I hand over to Tom, I just wanted to let you know about the Q&A box at the bottom. Please do sort of ask questions throughout the session. We'll be able to sort of cover those as we go along, but also at the end at the dedicated sort of little Q&A slot. So do use this time and ask those questions. We will be following up after with the video link and sharing the slides as well. And there'll be the option to sort of ask the experts any other questions after as well. So yeah, Tom, over to you.
Thanks, Rebecca. That's a nice introduction, and welcome everybody to the FREEDS Public Sector Equality Duty under the Equality Act webinar. My name is Tom Draper. I am a Director in Employment Law at FREEDS, and I am joined this afternoon by Tahera Khan, who's a Managing Associate in Employment Law from the Manchester office. So, today's agenda. What is the public sector equality duty? What is the requirement to have due regard under the public sector equality duty? And then I'll hand over to Tahera, and she'll have a look at some of the practical ways that your organisations can ensure they are having that due regard, including looking in detail at what an equality impact assessment is and how we should be using those to meet our public sector equality duties. So I think most of you will be familiar with the Equality Act and the way in which that act means that we need to treat our employees in terms of reasonable adjustments and in terms of preventing direct and indirect discrimination. But the public sector equality duty is slightly different. And this is a duty over and above the Equality Act, specifically in respect of public authorities. So the Equality Act applies to the provision of goods and services by both public sector and private sector organisations, but the Equality Act goes further in respect of public authorities in relation to the way that they implement decisions by incorporating something called the public sector equality duty. The public sector equality duty is set out in section 149 of the Act, and it explains that public authorities need to have due regard to three things, and they are, firstly, the need to eliminate unlawful discrimination; secondly, advance equality of opportunity; and thirdly, foster good community relations. So public authorities in this context are set out in a very long list in one of the schedules to the Act, but they cover all the public authorities that you were likely to think of, including local authorities, universities, educational establishments, and anybody, public or private, exercising a public function. So, for example, a private company running a prison is exercising a public function and would therefore be caught by the public sector equality duty. And the duty covers the normal kind of protected characteristics that we would expect to see, with the exception of marriage and civil partnership. So the public sector equality duty covers the protected characteristics of age, race, sex, sexual orientation, disability, religion and belief, pregnancy and maternity, and gender reassignment. And so when we are having due regard to the need to eliminate unlawful discrimination, those are the protected characteristics we've got to prevent people being discriminated against in relation to. So, what does due regard mean? Let's have a look in a bit more detail at that. In fact, before we do that, let's have a look at those three separate elements of the public sector equality duty. So, firstly, the need to eliminate discrimination. What does that mean? Firstly, it's the need to eliminate direct discrimination, which is the treating someone less favourably than someone else on the grounds of a protected characteristic. The need to eliminate indirect discrimination, which is having a policy, criterion or practice which treats those with a protected characteristic less favourably, even though the policy applies to everyone. So an example of that would be if there was a policy of including all absence in respect of disability and non-disability when applying a sickness absence policy, and that would have a disproportionate impact on disabled people and therefore potentially indirectly discriminatory. There's a need to have due regard to preventing harassment and victimization. So in this context, you might remember victimization means subjecting an individual to a detriment for doing a protected act. So, for example, complaining about discrimination. So that is a detailed look at what we mean by the need to eliminate discrimination. The second point is the need to advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it. So this would involve the need to remove or minimise disadvantage suffered by people who share a relevant protected characteristic, take steps to meet the needs of people who share a relevant protected characteristic that are different from the needs of people who do not have the characteristic, and to encourage people who share a relevant protected characteristic to participate in public life or in any other activity in which participation by such individuals is disproportionately low. And finally, to foster good relations between people who share a relevant protected characteristic and those who don't share that characteristic. So what it's important to note here is that actually this is providing a positive obligation on public authorities here, which doesn't apply in the private sector. So it's over and above the obligation not to discriminate. There are actually here positive obligations to remove disadvantage and to foster good relations, which don't exist in the private sector. And it can be a tricky balancing act here to have that positive obligation at the same time as making sure that you aren't inadvertently discriminating against another group of people with a protected characteristic as well, which would fall foul of other areas of the Equality Act. So I think it's helpful to look at a few examples of what I might mean by kind of positive actions here. So one example would be targeted training done by the police to ensure that ethnic minorities are proportionally represented in senior positions. That would be an example of a positive act by a public authority to remove potential disadvantage to one particular group of people with a protected characteristic. Another example might be a local authority setting up a mentoring scheme for disabled people with an interest in becoming local councillors. that would be an example of a public authority encouraging people who share a relevant protected characteristic to participate in public life. So what happens if we don't adhere to our public sector equality duty? Well, the Equality and Human Rights Commission is responsible for enforcing the duty, and the Commission first of all might start off by taking steps to encourage compliance by a public body before then moving to enforcement where appropriate. And there's a range of statutory powers that the Equality and Human Rights Commission has, including applying to the county court where they think that a public authority hasn't adhered to the public sector equality duty. And also interested parties who feel that they have fallen foul of the failure to, by a public body to have due regard to the public sector equality duty, can bring something called judicial review. Some examples of successful judicial review cases include an elderly woman who said that she was disadvantaged by the closure of her local post office. And in that situation, she alleged the post office and other bodies responsible for the closure hadn't had due regard to the impact that might have on older residents in that particular area. And she was successful with that claim via judicial review. Another example might be, and this is taken from case law as well, an example of people who brought a judicial review in respect of the closure of local law centres where you might get free legal advice. This might impact negatively on one area of people with particular protected characteristics, and therefore if we haven't had due regard to the public sector equality duty, then we might fall foul of judicial review in relation to that. So let's have a look at what we mean by having due regard. Now we understand what the public sector equality duty is. And as with lots of things, they aren't defined in the legislation, and we need cases and judges to tell us what they mean. And that is the case here with what due regard means. And you'll see on the slide there that the case of Brown and the Secretary of State for Work and Pensions set out some very helpful guidelines in terms of what we have to do to have due regard to our public sector equality duties. And firstly, they said it needs to be a real, active, tangible way of looking at those duties. And it shouldn't just be a box ticking exercise. I'm not going to read everything off that slide for you because you can read it for yourselves. But what I will do is just summarize what I think that this means in plain English. So for me, the obligation to have due regard means 6 things. Firstly, there needs to be a proper analysis of the situation. Secondly, there needs to be initial consideration of the public sector equality duty, and it shouldn't just be an afterthought or a box ticking exercise. Thirdly, it's a continuing duty. So it's not just a duty at the point that the decision is made. It's a continuing duty that exists once the decision is made and potentially when the impacts are being felt of that decision. Fourthly, it's non-delegable. You can't pass the obligation to have due regard onto anybody else. It needs to be rigorous and transparent. And I think here it's important to note the need to keep a written record, because in the the Brown case, the court was very critical of the fact that a proper written record hadn't been made to evidence the duty and the due regard to the public sector equality duty. So, like with all areas of litigation, if you haven't got the paper trail to show what you've done and the fact that you've done it, it's very difficult to then evidence that if you're challenged. So I would highlight that as and I know that Tahera is going to go into a lot more detail about how you do that. But that is one of the main things and the main areas that you need to focus on when having due regard to the public sector equality duty. So be rigorous and transparent, and part of that transparency is the written record. And then finally, there's also an obligation of reconsideration. So if new information comes to light, then you build on that fact that it's a continuing duty, and because it's a continuing duty, it potentially means that you might need to reassess, update your assessment forms, and make sure that you're continuing to have due regard to the public sector equality duty. So let's have a look at the next slide, please. The equality impact assessment and due regard. So the case law says that it is not a necessary requirement to do an equality impact assessment. But equally, without one, you're falling foul of one or two of the points on the last slide in the Brown case, and particularly the need to evidence the fact that you've had due regard to your public sector equality duties. So an equality impact assessment is likely to be the best way to evidence that due regard. And it also helps us as public authorities to identify the relevant facts that help give due regard to those duties, and to weigh those equality objectives against the purpose of the proposed policy. And it also makes sure that you can mitigate or remove any impact on protected groups. So although there's no legal obligation to complete a formal equality impact assessment, both case law and the Equality and Human Rights Commission favours this as the best way to ensure that we are having that due regard to public sector equality duty. So in short, it will be difficult to demonstrate due regard without showing evidence that appropriate analysis of the equality implications of a particular decision has been undertaken, and in many cases such analysis would be facilitated by an equality impact assessment. So most institutions, most public authorities on this webinar will have at least an informal equality impact assessment process already in place. And even if that was under the old scheme.
Yeah, it's on the local government webinar.
Yeah.
Yeah, I'm just running it anyway.
Right. I'm not sure what that interruption about, Rebecca. Not sure you're on mute. Anyway, I was just saying that the equality impact assessment is very likely to be the best way of showing that we've had the necessary due regard. So with that in mind, I'm going to pass over to Tahera, and Tahera is going to look at how to ensure equality duty compliance by having a look at equality impact assessments in a bit more detail. So I'm going to hand over to Tahera now. Can we have the next slide, please? Thank you.
Thanks, Tom. That was great. So Tom's helpfully set out the basis of the public sector equality duty. And I'm going to set out practically how you can ensure equality compliance. So what does that mean in practice? If we go to the next slide, you'll see that in summary, all public authorities should consider the following points when considering implementing a policy that might have an adverse impact on equality, as Tom has referred to. So the first thing that you should consider is that you know what the Equality Act requirements are. Tom has set them out at the start of this session, but it's always worth refreshing your memory. So if you have a process in place, if you have a document that sets out what your process should be, it might be worth just setting out the Equality Act requirements in summary at the top of that, because then you've got it at the front of your mind. Because the second thing is that you have to ensure that due regard is paid to the public sector equality duty and its requirements at all times during the decision-making process. So you have to consider it at the start of deciding the policy that you're considering, during and at the end as well. So you have to make sure that you actually know the principles that you're referring to in order to be able to do that. An easy way to set it out, I thought, would be to break down how you can ensure that you've paid due regard. So you would first start off with a proper analysis of the situation, the policy that you're implementing, and the impact that you think it might have. This should be your first and initial consideration, not something that you think about after you've done policy and after you've made the implementation. You've also got a continuing duty. So we all know that once you're implementing a policy, it might have a certain vision at the start, and that through whatever reason, red tape or issues that come up during the implementation process, or even as something you're discussing, you think actually this won't work. Things can change. So you need to make sure that you're having regard to your PSED throughout the decision-making process. We have come across it before where organisations have sort of outsourced certain aspects of policy making to third-party organisations. So this is where you would say, okay, we're going to hire a company to make sure that we've complied with our public sector equality duty during this policy making process. That's not acceptable. And if you're subject to scrutiny on it later, it's not a reasonable excuse to say, oh, well, we paid another organisation to make sure that we were compliant. So really, it's not our fault, it's theirs. The duty is very much on the public authority themselves. So if you're a local authority who's thinking about doing it, you have to take responsibility for that decision-making process yourselves. You can absolutely obtain advice and guidance from other organisations, but you can't pass the buck to them, so to speak. You have to take responsibility ultimately for yourselves. Tom has already said that the process needs to be rigorous and transparent. What does that mean? Well, transparent, it should be written down somewhere, published somewhere, maybe on your website. And rigorous means that you've tested it, so that you think about things from the people's perspective who it's going to impact. That's sort of the easiest way that I can think of to explain it. If you can show that you've considered a policy from all aspects, including the aspect of that person that it will impact in a negative way, and you've tried to reduce that impact in whatever way possible, then really you should be justified if you've implemented it in as sensitive a way or in as considered a way as possible. And also you have an obligation of reconsideration. So just because you've gone down a path of implementing a policy a certain way, you think it's ticking all the right boxes, that doesn't mean that you should just continue down that path no matter what. because there may be something that comes up and throws a spanner in the works and means that you have to completely reconsider the way you're implementing a policy, because you realise that it's adversely impacting a group that we hadn't really thought about in the first instance, or that we hadn't realised it impacts. So if you just sort of use it as something that you think about at every stage of the decision-making process, then that would be a good way to approach your policy making. Another thing to add is that, as I've said, you shouldn't delegate the entire ask of ensuring compliance with the duty to other organisations. But another way to think about it is the way that you obtain legal advice. So you would have an issue that arises in your local authority. You might call the solicitor to say, what's your view on this? But ultimately, you're making the decision for it yourself. If you dismiss somebody in your organisation, I might have advised you on that process. But if that individual takes you to an employment tribunal, it's your organisation that will have to get up on the stand and explain the decision-making process. So if you think about it in that sort of a mind frame, that's a good way to think about getting guidance from external organisations. Look at your functions as well. Obviously, if you have maybe a social care function, that's going to affect maybe more distinct and diverse groups than a planning function. So just by their very nature, some functions of your organisation will affect different and diverse groups of people. So you already know that if you're thinking about implementing a policy in one of those functions that's maybe a little bit more high risk, as we want to call it, you will have to tread carefully, because not only is that area likely to impact somebody with a protected characteristic, it's also an area where you're at higher risk of challenge later down the line. So just be conscious of that too. And ensure that you've got a procedure in place. I have referred to this at the start of this slide, but it really does help everybody involved if you've got a set process in place for ensuring compliance. That's firstly so that everybody knows what they're doing, and secondly so that it's done consistently every time. And this process is largely going to be identifying the policy, gathering the relevant data, assessing the impact. The equality impact assessment itself doesn't carry a standard format, but it's going to follow the same process of explaining what it's doing, explaining what it's looking at, explaining how it's going to work, and explaining the conclusions. But then don't forget, obviously, you have to keep revisiting it as you go along. So how would you do that? Let's look at some practical steps. So on the next slide, we can see how you would gather equality information. So firstly, when you're gathering information, it's important that as a local or public authority, you demonstrate the public sector equality duty compliance for the purposes of the Equality Act 2010, Specific Duties and Public Authorities Regulations 2017, which is the catchy title in case any of you wanted to specifically look it up and read it. But when considering the impact of a particular policy or procedure on those people with protected characteristics, the following things are likely to be relevant to those people who are gathering the information. So firstly, you should ensure that you've got sufficient information on the potential impact of a proposed policy. And it might not be something that you have to hand. And if you don't, you can look for other organisations that have gathered the same data, public authority organisations, and you can engage with those groups directly. You can do it by focus groups or review groups, but just make sure that you also engage with the less well-represented groups. So there might be a protected characteristic that is not very well represented by a set group that affects it. So there are, for example, with racial groups, there's quite a lot of different representative groups that would have spokespeople to speak for them, but not all protected characteristics are the same, and not everybody suffers from the same protected characteristic. There are some that are more common than others. So just make sure that you've covered off the areas that will be affected by your policy in sufficient detail so that if you're asked about it, you can produce a document, you can produce your evidence, and you can show that you've put your mind to it, to how it will affect that group. If you don't have much evidence about how a proposed policy is likely to affect certain groups of people, there are different ways in which you can arrange these focus groups, but again, try and make sure that you have a set procedure for doing that. And if something works well, make a note of it and report back so that that can be replicated for future policies, because that's the best way to really learn and streamline your process. Ensure that the discussions are clear and focused. Make sure that you have all your issues written down, all your questions written down beforehand, so that you obtain the most relevant information. And ensure that you consider any data protection issues. This recently has become more of a hot topic in view of GDPR regulations. And obviously you must be very careful in relation to storing any information that you've gathered. And just a small point at the bottom, it's not acceptable to say that we were unable to comply with the public sector equality duty because we didn't have the evidence. It's on us to obtain the evidence. So if we haven't got the evidence, we will have to set up a focus group or a review group and obtain that evidence directly. It might sound very labour intensive, but the quality of your impact assessment isn't measured on a page by page count, but it's measured on the quality of the analysis and the measures that you actually do take. So it's better to have quality rather than quantity when it comes to these things, which is why it's good to have a set plan and process in place, because it keeps you on task and keeps you focused. The obvious benefit to doing all of this is that engagement can help you to design more appropriate services that are relevant to the community that it affects, and then they're in turn likely to be more effective and they will make better use of your resources. You can also avoid the risks of and costs of remedying and adapting the services if they're implemented and then you find that there are lots of complaints that arise because they're not fit for purpose, which again will be sent back to you to go through the same process to change the policy and the way that it impacts whichever group has complained about it. So if you really obtain good quality and focus information, it can circumvent a lot of problems that might occur later. And your engagement with people with protected characteristics and other stakeholders can also be useful for fostering good relations with the local community, because it gives you the opportunity to explain what you're doing with regards to equality and why you're doing it. So you're in effect having a chance to explain the rationale behind it, and hopefully people can see why you're doing it is a good reason and that it will in the long run hopefully help them. This will also make it less likely that myths develop about favoritism and favouring a particular group or positive discrimination towards certain groups, which can cause bad feeling and can often just result from a lack of information. So the more transparent you are, really, the better. If we go on to the next slide about using equality information, once we've gathered the information, we have to use this to further our aims. So when using the equality information, firstly, you should consider potential data protection issues, which is what I've just briefly touched on. For example, when you're dealing with a small number of people with a protected characteristic that's quite specific, that might make them more identifiable. So you have to consider then how we're going to protect their identity. Consider maybe anonymizing any published information in order to keep it confidential. It's also good practice to keep records of all decision making, as Tom said, including considerations of the public sector equality duty. And this will also assist you when you're dealing with Equality Act claims or judicial review actions, as Tom was explaining, by demonstrating that you have the evidence that due regard was given to the public sector equality duty at all times. That will definitely help you in the event of a claim. Consider benchmarking the existing information processes to ensure that your information is being gathered in the most effective way. as well as perhaps getting ideas from other public authorities as to how they're gathering and using equality information. I understand that you generally have good relationships with other local authorities around your area, so it would be a good idea to share information about processes and procedures. I know it can take time to do that, and everybody's short of time nowadays, but it would be useful to share information in that respect if you've got a good relationship. And then consider publishing the records of any decision making or findings on your website, because this sends out a message that you are reassuring the public that the legal duties that you needed to take were considered, and it might also deter unnecessary legal action because you're essentially putting the information out there for anyone to see, and it shows that you're confident about your process, not got anything to hide, and you're quite happy with the process that you've followed. The gender and disability duties actually do recommend publication, so that's worth bearing in mind too. And finally, you should consider publishing a summary and reasons why points that were brought up but not taken on board were decided in that manner. So if you've had certain issues that people have raised and you've decided not to take those on board in the final decision-making process, why is that? So again, this will reduce your risk of challenge later on if you can provide cogent and reasonable reasons as to why you've not taken these points on board. So it's worth considering doing that. It's quite a confident step to take, but it's a worthwhile step to take too. If we go on to the next slide, assessing the equality impact of a policy. When you're doing this, as Tom has stated, you don't need to do an equality impact assessment, but it is a really good way of evidencing the reasons behind any decision-making process. So if you are going to do this, then as an overview, this would follow a format of, firstly, what is the policy? Secondly, who may this potentially impact? Third, what's the evidence we've gathered? This is all the evidence that we've gathered and how we've done it. Then fourth, these were the points that were raised during that evidence gathering process. Fifth, we've considered this in light of the public sector equality duty and the due regard obligation. And how have you done that at all points of the decision-making process? And then sixth, these are our findings and how we're going to mitigate the impact on the affected groups. And then lastly, these are the next steps that we're going to take. And then don't forget, if you would like to, you can also have a section which says these are the points that were raised that we're not taking into account, and these are our reasons for not taking them into account. So remember that some policies may have no impact at all, but you still have a requirement to have due regard to the PSED. So you still have to provide evidence that there's no impact. You have to show that you've thought about it, that you've tried to assess whether there's an impact, and your findings are that there is no impact. And remember, equally, your impact assessment might find that there are going to be adverse impacts that can't be managed, no matter what you do. But the policy, on balance, still needs to be instituted. So it's important to have evidence as to why this decision has been taken and how. In terms of your decision making, where there's a large number of people with a particular characteristic that are likely to be affected by your proposed policy, then the weight that you give to the public sector equality duty needs to be a heavyweight. So you need to consider the PSED with more weight than you would usually if it's going to have a high impact on people. Remember, in some cases, equality impact decisions may encompass a number of different areas that will need to be assessed. So in addition to having all of the relevant information, consider the cumulative effect of each aspect of the policy that the decision is then public sector equality duty compliant, and just ensure that it is as far as possible. So when you look at the whole thing together, what's the impact then? When you're implementing a policy that's been formulated elsewhere, then carefully examine how you're going to implement that locally and how this will affect your local community, because everyone's different local authority will have a slightly different impact on their community. There are lots of different areas of deprivation, and this will vary from local authority to local authority. You're not going to all be the same. To ensure that your policies are all assessed in the same sort of way, consider adapting a standard method for doing this. So, as I've said, a set procedure is really handy for that reason. And then you can assess the potential impact on equality of a proposed policy in the same way each time. If you are concluding that a policy won't have any impact on equality, please make sure that you have really strong and sufficient reasons for reading this conclusion, because they will need to stand up to internal and external scrutiny. If you're saying that your policy has absolutely no impact on any group, you will need to be able to stand up and justify that. So do be careful before drawing that conclusion. And remember that equality should be considered alongside other factors, of course, but you can't avoid the public sector equality duty. So compliance by claiming that you have the resources to comply is not an acceptable excuse, just as not having the relevant evidence is not an acceptable excuse. You have to be very careful in the reasons that you give for not being able to comply, and they should be very few and far between. It's not good enough to say that, oh, well, this is just something that had to happen. You have to have very set analysis before reaching that conclusion. Finally, if you've considered all of the relevant information, if your policy is amended or dropped or continued as a result, ensure that your reasons for doing so are well documented, just to show that your decision is justified. Tom stated before that it needs to be a rigorous and transparent process. So whatever decision you reach, just make sure that you've carefully logged the end as well. So what's your decision and why? Because if you get a challenge, it's much better to be in front of a judge with a lot of information behind you, rather than to have to stand up as a witness and explain a decision-making process that you might have taken 12 months earlier. It's a lot easier for you to just be able to refer to documents in that unfortunate situation. Equality impact assessments aren't an end in themselves, however. They're a way of showing that you've had due regard to the PSED and the general duties of the local authority. They should be used to make a final decision. If you're using one, they are very useful documents, but just make sure that the information in there is quality information and that it will stand up to testing. If we go on to the next slide, finally, we've got some considerations for ensuring that the public sector equality duty is complied with on your existing policies and procedures. So just remember that the duty is ongoing and continuing. So if you've got existing policies and procedures in place now, it would be a good idea to revisit them at a set time, maybe annually, maybe more often than that, after their initial implementation, to ensure that you are continuing with the public sector equality duty requirements. You could have had due regard at the relevant time, but if you don't review your policies and procedures, it's likely that you'll fall down on the obligation of reconsideration, and then you'll have a technical failure to comply. With regards to your existing policies and procedures that were assessed under the previous equality regime, so before the Act came into place, because I'm sure you've all got policies in place that might have been going for a very, very long time, just ensure that any necessary additional steps are taken to make sure that these still comply with the public sector equality duty in terms of the protected characteristics, because the old equality schemes are similar. So, disability discrimination had its own act before, and now it's under the umbrella of the Equality Act, but they're not exactly the same. So it's best to consider them under the new rules that we've described. And if you don't have a regular review process in place, then I would suggest that you should urgently implement that. And it would be a good idea to establish a timetable to periodically review your policies for PSED compliance and assign certain staff in your organisation to be responsible for reviewing these policies in future. Because if it's given as a job to somebody and it's part of their job description to do that, then it's far more likely that it'll get done and it won't fall through the net in terms of your compliance, because obviously it's very important that you do that. Separately, we see tribunal claims all the time relating to discrimination, and actually if an organisation can say we are an equal opportunities employer, we're very aware of our compliance duties, and actually as part of our public sector equality duty we review all of our policies at X amount of times, and this particular policy has been reviewed 6 times since implementation. That's quite a strong point to make. So even from a claims perspective, it will help your organisation if you have robust procedures in place. That comes to the end of my section. I believe that we had a few questions sent through to us. So Tom, do you want to lead with those?
Yeah, absolutely can do. Thanks for that, Tahera. So we had a couple of questions. The first one is probably one for you, Tahera.
Yeah.
It says, is there a good precedent Equalities Act assessment form available, as there seem to be several in use?
Well, I have in overview set out some of the points that should be in a good equality assessment impact form. If you would like us to create a precedent form for you to use, or to review the one that you're currently using, we can definitely do that. So it will be worth you contacting Tom or I after the session. But for your own organisation's purposes, I would say that it's best to have one template that you're using if you are using an impact assessment form, just for consistency purposes. So whether you come to us for review or not, I would definitely make sure that you have just one precedent form that you're using.
Okay, thanks. On that, Rebecca, could we have our details on the slide? Just, I'm conscious that Tahera's mentioned the possibility of getting in touch with us after this webinar. I think the final slide shows our details. Okay, the next question is very specific to disability, and it doesn't really cover what we've been talking about in the seminar in terms of the wider public sector equality duty. I'll answer it anyway, but I will also explain that actually this highlights the difference between the duty to comply with the Equality Act generally and the specific public sector equality duty that we've been talking about. So the question is respiratory illness lasting more than 12 months classified as a disability under the Equality Act? And is any sickness linked to this illness excluded from sickness monitoring? How is suspected COVID and long COVID treated for sickness monitoring purposes and triggers? So there's 3 questions in there, but they all relate to the way in which public authorities as employers will treat their employees. And that's separate to the public sector equality duty, as hopefully you'll have picked up from the webinar. The public sector equality duty relates to decisions, policies and procedures of public authorities rather than specific decisions in respect of individuals. Obviously, those policies and procedures may affect individuals, and that would be then the subject of a public sector equality duty. But in terms of these questions, they're more specific and they relate directly to individuals. Is a respiratory illness lasting 12 months or more classified as a disability? Well, it would be if that respiratory illness substantially affects that person's day-to-day activities. And that leads me into the answers to the next questions. If someone has a disability and they reach that definition, then it is a good idea to exclude any disability-related absence from the sickness monitoring process, because that would potentially be a reasonable adjustment, and it would also avoid a potential claim from that employee for being dismissed for something arising from a disability. In terms of COVID and long COVID, the same definition of disability would apply in those situations. So it probably wouldn't apply to COVID because that's short term, but it's certainly possible for long COVID to be a disability if it is a long-term substantial. If it is long-term, it has a substantial effect on day-to-day activities. So the final question is, how does the public sector equality duty apply to reasonable adjustments for staff employed by public sector employers? And again, that there's a distinction here in respect of the decisions that public authorities make in respect of individual employees and the policies and procedures that apply to everyone. So I think that's a neat way of explaining the difference between the two. The public sector equality duty applies to the procedures and the policies, whereas normal Equality Act considerations would apply to decisions made about individuals. Let's have a look and see if we've got any questions that have been coming through while the webinar has been running. Right, we've got quite a long question here. Appreciate this CPD is directed to public sector requirements, but on large public sector decisions in relation to, for example, a development proposal, is there a specific requirement for the private developer to also consider this, or can they work with the local authority to ensure the public sector equality duty requirement is met and therefore reduce the potential judicial review risk? The answer there is, if the private sector company is exercising a public function, then there is the public sector equality duty requirement on them. In this particular example, where you're looking at presumably a housing or other kind of construction development proposal, the obligation would be on the private company then to work with the local authority to ensure that the local authority meets its public sector equality duty. And I'm sure that if you've got a good contract with the developer, the private sector developer, that contract would require them to work with you as the local authority to ensure that your public sector equality duty is met. Great, I think that's all the questions covered. You've got our details on the screen if you've got anything specific that you want to ask either of us. Tahera, have you got anything you want to add to any of the answers I gave to any of those questions?
No, I think you covered everything, Tom, beautifully.
Fantastic. Right, in which case I will say thank you very much for watching this webinar, and I wish you a very good rest of the day, and please do tune in to further EM Law Share webinars from Freeth. Many thanks.
Thank you.